Welcome back to Lecture 2 in Week 2 of this course on Constitutional Studies. In Lecture 1, I focused on the question, how should a society make a constitution? We considered different models of constitution making and identified that the Indian constitution makers chose a special representative assembly, namely the Constituent Assembly, to make the Constitution of India in 1950. In this lecture, I will focus on the last three questions for Week 2. Of the three questions, I will spend much of my time to explore how did India make the Constitution of India in 1950. The story of Indian constitution making is reasonably well known, but it's important for us to unearth some critical ideas about who were the members, what were the processes adopted, and some key issues that came up before the Constituent Assembly. Then I will turn to question number 3. Now that we have made a constitution, can a constitution change? If a constitution were to change, how do constitutions change? I will close out with a very brief assessment to the question, an assessment and a response to the question, can Parliament amend or replace the Constitution? And this has much to do with the evolution of constitutional history and politics in India, and I will not cover that in the greatest detail, but will spend some time to give you an idea at least of one key event in Indian constitutional and political history. So let's begin. How did India make a constitution? Let's begin with a broad overview. The demand for a constituent assembly comprising only Indians was made in the early part of the 20th century. M.N. Roy, a very interesting figure in Indian politics and history, wrote and argued for this in some early work. The Congress Party had already adopted some resolutions to this effect in the early part of the 1900s, and as we worked our way towards independence in 1947, this demand for an Indian Constituent Assembly grew louder and stronger. The Indian Constitution makers and the Indian freedom movement expressly rejected the possibility that British Parliament or a British expert committee or an expert committee comprising Indians and the British would make the Indian Constitution. And they made it very clear that this was not the plan for a post-independence India. So finally, when the Constituent Assembly was created through the Cabinet Mission Plan, it had a mix of elected and nominated members who were brought together to make up the Constituent Assembly. I will say a little more about this later in this talk. The final imprimatur on Indian independence was delivered through the Indian Independence Act. The Indian Independence Act was enacted by British Parliament, recognizing the transfer of power and the conferral of legislative authority on Indian Parliament. This act was finally repealed by Article 395 of the Constitution, thereby asserting India's autochthonous sovereignty or autonomous sovereignty. What did the Constituent Assembly do? It sat for about 166 days. There were some early drafts that had already been prepared prior to the Constituent Assembly sitting. They reviewed, discussed, modified, and finally adopted these drafts by the entire Assembly. So in the slides to follow and through much of this lecture, I'm going to reflect on the details and the institutions through which constitution making in India was processed. This overview slide gives you a broad sense of what is to follow in the rest of this lecture. Let's begin by identifying the key institutions that were involved in constitution making. While I have spoken so far about the Constituent Assembly as a whole as being one key institution that made the Constitution, we must recognize that it didn't at all times sit all together in a plenary session. The assembly was broken up into various committees which played important roles in fashioning different parts of the constitution. The drafting committee, which brought together not only the work of the plenary sessions, but also the work of the various subcommittees of the Constituent Assembly, played a key role in pulling together and then fashioning the overall constitutional document that we now know as the Constitution of India 1950. The last body, institutional body, that had a key role in Indian constitution making was the Congress Assembly Party. You must remember that the Congress Party was not just a political party, but it was the party of the freedom movement. It was a large umbrella tent which included all kinds and strands of political opinion and beliefs that had been put together in a coalition committed to the freedom from British rule. So the Congress Assembly Party also convened simultaneously with the Constituent Assembly as a separate party body. Key figures in the Constituent Assembly were not members of the Congress Assembly parties. I'll just take one as an example. Dr. B.R. Ambedkar was not a member of the Congress Assembly party. It is reasonably well known that some discussions regarding the structure and form of the Constitution occurred in the Congress Assembly party. And so it's fair to say that it was an important institution in constitution making. Let's be clear as a historical matter that the entire proceedings of the Constituent Assembly are duly recorded and stored in and archived in multiple volume sets that are available from the Union government's publishing departments, but also available on websites including constitutionofindia.net. The works of the committees of the Constituent Assembly are less accessible. Some reports are available in collections like the collection by Shiva Rao. Other reports are less accessible and are found in archives. And it is an important job for both historians, scholars, and for the general population that we make these committee reports more accessible to the public at large. The drafting committee's outputs are reasonably accessible in the Shiva Rao collections as well as in the archives. It is the Congress Assembly Party for which we have no structured historical records. One may glean from autobiographies and biographies of important political figures that constitutional discussions did occur in the Congress Assembly Party. However, we don't have a structured record of the deliberations in the party sessions. Putting all of these institutional actors together, we can picture the process of constitution making between the period 1947 to 1950. Constitution making, mind you, didn't begin in 1946. It began arguably almost 70, 80 years ago, when early versions, proto-versions of an Indian constitution were made by various actors in the freedom movement and beyond. The British also produced some versions, governance documents for India, including the Government of India Acts. And these are all these are key documents that make the long history of constitution making in India. So for anyone interested in that longer history, you would want to explore these historical antecedent constitutions that finally result in the Constitution of India 1950. Whatever else we might think, we can be reasonably certain that the constitution that we arrived at in 1950 was the result of concerted effort of nearly a century between Indians and occasionally some British actors. What does the Constituent Assembly look like? And here I've shared with you an early photograph of all of the Constituent Assembly members. This might be very small on your screen, but for those of you who have access, please go out and explore, and you will see as you work through the list of members that you see some of the most significant figures in Indian politics and public life who are a part of this assembly. It is a stellar assembly that we simply cannot imagine as being the representative body of all Indians in contemporary times. So this kind of time and attention was spent to ensure that the Constituent Assembly both drew on the best talents that the country had to offer, legal and political, as well while maintaining a wide diversity of representation, not just of religions, castes and communities, but also of political views. And it's that coming together that the Constituent Assembly represents. The drafting committee, pictured in the second photograph on the slide, is a much smaller body, but a body that labored through the most difficult parts of Constitution. Dr. Ambedkar, as the chairman of the drafting committee, sitting at the center of the photograph, was one person who has his imprint on almost every article that emerged from this Constituent Assembly. And one requires an astute admiration and understanding of the singular role he played in crafting this constitution. Many times it's been argued that this assembly was not representative enough, didn't have enough women, it didn't have enough representation from the backward classes, from the Dalit communities, or other shades of political opinion. And it is fair to say that no assembly, no constituent or otherwise, would be perfectly representative of a country as diverse and as separated as ours. And the Indian Constituent Assembly did a fair job of putting together key constituencies. But in our day and time, we might argue for forms of representation and extent of representation that is quite different from the structure of this Constituent Assembly. And this is a question that all of us must pay attention to and understand better. You will see in the link attached a very short video to the role of women in the Constituent Assembly. Though they were fewer in number than their proportion in the population, they played a significant role not just in Indian constitution making, but also in the drafting of the Universal Declaration of Human Rights and some key international human rights treaties created at that time. Let me move on now to the stages of constitution making that emerged in the period immediately after the creation of the Constituent Assembly. We begin by noting that the early months were spent primarily in the committee stages. Different committees were constituted. Let's say a states committee that deals with federalism and provinces, a human rights committee, fundamental rights committee that deals with the fundamental rights in the Constitution, and so on. So several subject matter committees were created and tasked with producing a few articles or chapters of the Constitution. The next stage that deserves close attention is the preparation of a draft constitution by B.N. Rao. B.N. Rao is a critical and important figure, and there's a recent interesting biography of B.N. Rao that I would recommend to all of you. B.N. Rao was a civil servant. He was not a politician, and he was not an elected member of the assembly. He had a position that was called a constitutional advisor. He was partly a secretary to the drafting committee, but had a key role in putting together these documents with the kind of meticulousness it takes to produce as voluminous a constitution as we had. Once a draft constitution was put together in late 1947, there was a public circulation of the draft constitution. Not many people are aware that the Indian draft constitution was circulated to the general public and draw thousands of comments. Comments that were all recorded and archived from the most diverse actors across the country. Small associations from different regions in the country, community groups and other interest groups, journalists and so on, were writing in response to the draft constitution, arguing out positions either in support or against the early drafts. The debates then moved into the Constituent Assembly, and in the early sittings of the Constituent Assembly, some of the important contours of the Constitution of India as we know it, the broad shape, was settled in these early debates. We then have the revisions of the draft constitution, which was a meticulous article by article process. Not every article was discussed to the same length or extent. Some were easily accepted, others were hotly contested, and those debates are captured in the Constituent Assembly process. We then move finally towards the adoption of the Constitution. While the debates on articles of the Constitution were often followed by a vote, a division between the Constituent Assembly, where some members agreed and others did not, the adoption of the Constitution was carried out through a unanimous adoption. All members of the Assembly came together to adopt the Constitution as the final document. And we now celebrate that day of the adoption of the Constitution, 26 November 1949, as Constitution Day. The Constitution finally came into effect on the 26th of January 1950, the day we call Republic Day and celebrate as Republic Day. So notice here that the stages of constitution making across that period of a little more than 2 years is marked by a journey through the institutional, the key institutions that we outlined in the previous slide. The Constitution early drafts emerge from the committees, consolidated, they go out to the public, come back into the Assembly, are carefully debated and discussed, re-put together by the committees, and then finally adopted and enacted. This understanding of the constitution making process is crucial for our appreciation for the nature of the constitution we have and the difficulty that was, the rigor and difficulty that the process of constitution making requires. Let's turn our attention now to the membership and the composition of the Constituent Assembly. So I mentioned earlier that it was partly elected and partly nominated. Let's dive a little deeper into these members and look at a few key members. The Constituent Assembly all put together had 299 members, of which 15 were women. I mentioned that there were not as many women, but some of the women members were very prominent and influential. 229 members from among these 299 were elected from the British provinces, and 70 were nominated by the princely states. Now, for those of us who are not so clear about the nature of British India, maybe we need to pay a little bit of attention to the political map. While the British provinces occupied nearly 60 to 65% of the territory of India, and these were directly ruled by the crown, about 30-35% of the territory of India were ruled by princes of various sorts who had entered into treaties with the British Raj. So while they were princely states, they had some arrangements, some tighter, some weaker arrangements of treaties with the British state. So when the British Crown created, the independent India, there was a choice to be made. While it was clear that the British provinces composed a single political unit, the princely states were not so cohesive. And as we know, some of those lingering debates about how princely states joined the Indian Union remain politically controversial today, as we know with the recent amendments to the status of Kashmir. Members from provinces were indirectly elected through a single transferable vote of the members of the 1946 provincial legislative assemblies. Now, when we remember that the provincial legislative assemblies created by the Government of India Act 1935 had democracy, it was a democracy with a limited franchise. Approximately 30 to 40% of the population at that time had the right to vote. Now, these voters elected their assemblies. The assemblies in turn elected their representatives to the Constituent Assembly itself. So you would call the Constituent Assembly indirectly elected assembly, much like the Rajya Sabha is today, composed of it's one level removed from the popular electorate. Right? We also recognize that unlike the assemblies today, the provincial legislative assemblies under the Government of India Act were elected by a limited franchise. Now, members from the princely states got involved after prolonged negotiations because, as I said, the status of the princely states after independence was not a foregone conclusion. They had to be negotiated, and the Indian Union had to negotiate individually with many of these princes to cajole and in some instances mildly coerce these princely states to come into the Indian Union and to send their representatives to the Constituent Assembly. That history of Indian nation making is wonderfully told by V.P. Menon in his account of that process, a process in which he was closely involved, and also by Ramchandra Guha in his story about the making of the Indian nation, his history of making the Indian nation. While 80% of the members, all these processes, after these indirect elections, after these princely state nominations, 80% of the members in the Constituent Assembly were from the Congress Party. The remaining were from the Muslim League, the Akali Party, the Communist Party, and a few independents. You must remember that when the Constituent Assembly was first put together, the Muslim League was a significant presence in parts of British India that now are parts of the nation states of Bangladesh and Pakistan. The Muslim League had a significant presence in other parts of India, but with the partition of British India into these states, the Muslim League lost much of their presence in the Constituent Assembly, and this was one of the early founding battles in the Constituent Assembly. And while it is partly captured in the debates, one would have to read elsewhere to understand why the members of the Muslim League took the view that they could not participate in the Constituent Assembly as it was initially constituted. So much for the Constituent Assembly members and the broad outlines of that assembly. I'm going to move on and focus on some key members, some of whom are well known and others less so. I think Dr. B.R. Ambedkar has witnessed a resurgence in the public imagination and salience in political life it was not something that he was not as prominent in the 1950s and 60s, because there was a failure to recognize how someone born to a Dalit family and was educated initially after receiving scholarships in a princely state, and then the scholarships to study abroad at Columbia University and the London School of Economics, that someone as erudite and accomplished as Dr. Ambedkar was not only involved in the political movements of India, including related to the empowerment of scheduled castes, as well as the labor movement, and had started his own party, was keenly involved in the roundtable negotiations. So he was a very significant figure, but not a figure who emerged from within the Congress fold. And when the history of Indian constitution making is told, it's very important that we begin with Dr. Ambedkar, because his is not just a story of personal triumph coming from adversity, but a story of an exceptional contribution to constitution making in a republic that, to most political watchers from the outside, had an unlikely odds of success. He was the chairman of the drafting committee in the Constituent Assembly, and the role that he plays as the chairman of the drafting committee establishes him as the pivotal figure around which the Constitution of India 1950 was built. Post-constitution making, he became the first law minister of independent India, and his resignation on questions related to the Hindu Code Bill and others is one of the early political crises faced by the post-independence government. But those are very important concerns, but ones that I will leave for another occasion. So Dr. Ambedkar was a key figure in the constitution making process and in the Constituent Assembly. The Constituent Assembly is replete with debates and references where he played a part, and you almost can't read those debates unless you notice that he makes a key intervention here or a nudging intervention in some other place. Maulana Abul Kalam Azad came from a very different background. He came from a religious family, was born to a renowned Islamic scholar, but was deep and had an education that was steeped in Islamic scholarly traditions. But he came to be very highly influenced by the writings of Sir Syed Ahmad Khan, who is a crucial figure in the evolution of the Indian ideas of the nation and the place of the Muslim community in that nation. And what he did was that he initially began to gain prominence by the quality of his writings as a journalist and as a speaker in this field. He found common cause with the freedom movement around the Khilafat movement and was inspired by Gandhi to then come center stage in the Dandi March and the Quit India movements. Not only was Abul Kalam Azad a key figure in the Constituent Assembly, he also came to be the Minister for Education from 1948 to 1958, critical decades in the formulation of education policy in India. The third figure that I want to spend some time on is Dakshayani Velayudhan. Dakshayani Velayudhan didn't come from either educational or social privilege like Abul Kalam Azad. Was born in a lower caste family in Kerala and then became the first woman scheduled caste graduate and a teacher in Thrissur in Kerala. She entered politics very early. At the age of 34, she entered the Constituent Assembly. She had already contested and won elections. Sorry, she'd been nominated to the Cochin Legislative Council, and she had developed a place of intervention on the question of caste discrimination. She continued with this civil society work post-independence and set up a women's organization that worked on issues of gender empowerment and caste post the constitution. So Dakshayani Velayudhan was also a member of the assembly, and while there are not as many speeches made by her as say made by Dr. B.R. Ambedkar, she plays a critical role with her participation and voice in the assembly. I'm going to close this round of key figures in the Constituent Assembly by talking about Jaipal Singh Munda. So Jaipal Singh Munda came out of the present-day state of Chhattisgarh, was born in a tribal family, but had worked his way up in two senses: to study at Oxford on a scholarship, but also to become a key hockey player representing in the Indian men's hockey team as a captain in the Amsterdam Olympics, where India went on to win an Olympic gold medal. But Jaipal Singh Munda was not just any other hockey player. He also was a key figure and a key voice on the questions of tribal rights. He was the president of the Adivasi Mahasabha, where he remained active during the constitution making period and after on questions of tribal rights in India. He played a crucial role in key debates in the Constituent Assembly and argued that the original people of India must indeed gain both more political representation and the political autonomy to govern themselves. So Jaipal Singh Munda rounds off our four figures that I want to spend some time on. You will notice that almost every figure in the Constituent Assembly has a remarkable history, both about what got them to the Constituent Assembly and then what they went on to do post the Constituent Assembly. And I would invite you to explore many of the other figures who played a critical role in constitution making in the Constituent Assembly. Now I will turn from the questions of membership, who made up the Constituent Assembly, to questions of the debates. Oftentimes, it is mistakenly portrayed as if the Constituent Assembly was a lame bureaucratic organization and that the Constitution was somehow mysteriously produced by some other process. It doesn't somehow reflect the work of Indians who sat in the Constituent Assembly for this long period. And so I want to spend some time outlining the process and the debates in the Constituent Assembly. This is a wonderful resource for any young person who is interested in understanding why we have created the kind of political society that we currently inhabit. And I would encourage all of you to go to these debates, to look for new ideas and old. The Constituent Assembly sat for the first time on 9th December 1946. We have already looked at the stages of constitution making, but let's look at a few key numbers. It sat for 166 days, but these 166 days were spread over a period of 2 years and 11 months. In between the sittings, there was the public consultations, there were the synthesizing of drafts, and all of these other activities that go into making the Constitution what it is. The final session of the Constituent Assembly took place on 24th January 1950 in preparation for the 26th event where the Constitution was brought into effect. I mentioned earlier that the transcripts of the Constituent Assembly are well preserved, available in print and online. They're divided into 12 volumes, and each volume it focuses on a specific time period that you may be interested in. Volumes are further divided by date So each unit of the debate is a date on which these debates occurred. So this is the overall description of the Constituent Assembly debates. Let's pay some attention to how the process by which an article was proposed, how it meandered its way through that assembly and arrived in its final form. So, as a hypothetical, imagine that a day of the assembly would begin with the president of the assembly announcing a draft article to be debated on that day. Members who proposed amendments to the draft article would speak and suggest why they were proposing these drafts and what needed to be changed. The proposing member had the opportunity to both defend the draft as it stands, and more often than not, Dr. Ambedkar was left to stand and defend the formulations in the draft constitution. After all amendments were proposed, members would speak either in favor of or against the proposed amendments. This would go beyond those who had formally tabled amendments. Members were allowed to express views either in support of the draft article or in support of some particular amendment. Amendments were made to draft articles, and draft articles, or the article to be adopted, was finally put to majority vote through a voice vote in the event that a unanimous view could not be developed. The Constituent Assembly debates reveal that there are occasions when members asked for a division vote and those division votes were recorded. Once the individual articles are crystallized through this process, a deliberative and voting process, the Constitution is put together in a consolidated form. But this consolidated Constitution of India 1950, as I mentioned earlier, was adopted by the Assembly in full. So the entire Constitution was adopted, and adopted without dissent. So while there might be dissents with respect to a particular article, it is both symbolic and politically salient that the Constitution as a whole was adopted unanimously. It gives us caution and pause to think today, if we were to give ourselves the tasks of making a constitution, would we satisfy that threshold where all members present, a very diverse Constituent Assembly, would put their signature and pen to the final outcome unanimously? That is the threshold, the political threshold, that the Constitution of India met in its when it was adopted. I'm going to focus now on a few key debates, debates that have political relevance today. And what I want to do with this exercise is to actually confirm and allow all of you to see that these debates are serious debates, well-informed debates of members who may not always disagree, who may not always agree about the end outcomes and what the Constitution must look like. Let's begin with a debate around free speech and the contempt of court. All of you are familiar that in the last month we have had a contentious Supreme Court proceeding around the question of contempt to be used against a lawyer for some communications. When we read T.T. Krishnamachari's intervention, and I'll just briefly excerpt and summarize his intervention, he says, look, a person might be speaking on a matter which is sub judice, that is a proceeding that is ongoing in court, and interfere with the administration of justice. And we don't have a category of offences. This category of offences is not an exception to the free speech clause. And so, if you want to allow, if you want to ensure that courts function in an unhindered way, you have to allow for a contempt of court offense. So it's arguing for a contempt of court to be an exception what is now Article 19, the free speech clause. R.K. Sidhwa responds, yes, we know that there should be a contempt of court, he tells us, and he says, yes, judges may exercise their powers as if they are infallible and do not commit any mistakes, but indeed they are liable to commit mistakes. So what is the reason for us to carve out an exception for contempt of court? What is more important, Sidhwa mentions, is for us to protect the interests of the public. So it's all right if a court and a judge makes any observations of any sort and public comments on it. It would keep the judges on their rails. As it turns out, Article 19 did carry an exception that allowed for the contempt of court, and as we know, these debates are alive and with us in our contemporary political situation. Let's briefly discuss universal adult franchise. Now, most of you know that India was a country that adopted universal adult franchise, right from when we got independence, and into our constitution makes no staggered approach to the question of whether only people with property or people with education or people male or female would have the vote. Almost everybody had the vote from the start. So this was while this was an article of faith in the freedom movement, there are debates in the assembly about whether we should adopt this in full. While in opposition to the British, arguments were made that we must adopt universal adult franchise, these were questions that came up for discussion in the Constituent Assembly. So Kunzru is the first view that we encounter on this slide, and Kunzru is hesitant about whether a universal franchise is necessary at this stage of development. He is particularly concerned that with universal franchise and with low levels of education and low levels of development, that we might actually allow for a kind of demagogy, allow for a popular authoritarian leader to emerge who can rouse the masses with rhetorical speeches, and not allow them to be, as he puts it, they may not have the sense of discrimination and restraint on which the successful exercise of democracy depends. So Kunzru expresses some skepticism about whether the Indian Constitution should at this stage, and he says maybe 15 years later we could adopt universal adult franchise. In response, Alladi Krishnaswamy Iyer goes in the opposite direction. He suggests that the ignorance and illiteracy of a large mass of Indian people is not a constraint, and that we must adopt a principle of universal adult franchise, having faith in the common man and a sort of native wisdom that we can assume that need not come from formal education, but might come from people who have a sense of a general sense of the good society that they want to build. So he suggests that it's not the adoption of universal adult franchise is not a whimsical decision. It's one that recognizes that ultimately the governments must depend on the faith and the confidence of the people. So when large masses of people are illiterate and those who own property are so few, any form of limit on the franchise would result in a very minor base of people who would have the opportunity to elect their leaders. And hence, as we know, that Krishnaswamy Iyer's view wins out on this question. There were other participants in the debate, but just for the minor example that we have, that his view wins out and India adopted universal adult franchise right from the start. The third debate that we will spend a little bit of time and attention on is the debate on federalism. Once again on federalism, there were sharply divergent views about the nature of the balance of power between the central government and the states. Kengal Hanumantaya in the first excerpts says, if you compare the Indian constitution to other constitutions, there seems to be a lack of freedom and autonomy to the states. We seem to give the central government too much power and allow them to make the decisions that might over a period of time undermine the states. And he expresses some skepticism about whether people coming from the princely states would be comfortable with this kind of strong central government. Annie Mascarenhas, in response, suggests that the international and the crisis context in which the Indian nation has emerged might require a strong central government. It may be that if we don't have a strong central government, the nation itself may not survive due to both external pressures and internal pressures. And hence she suggests that a strong central government approach might be a way out. Now, what is striking is that after partition and the partition of British India and the widespread and ugly violence that followed, that the concentration of power in the center increased, and we find that the Constitution of India, as we adopted it, finally became a constitution that had a very strong emphasis on central power. So those are three debates that we looked at to give us some idea of what the constitution making process was like. At the end of that process, the members came together and signed a beautifully designed and artistically produced document that is the original Constitution of India. And you can see in this photograph members lining up to put their signature on this document. Copies of this document are available at various museums and universities, and also images of these documents are available on the internet. And I would encourage you to look at them, not just for the text and the language, but the beautiful calligraphy and design of this. What is the Constitution of India 1950? What is putting all the parts together? What does it look like? It's clearly a very long constitution. We understand that. It's divided into 22 parts. Each part has a title, and these parts are subdivided into chapters which have specific titles. 395 articles altogether, and there are numerous lettered articles and subclauses. So if you want to count every single clause in the Constitution, 395 is a way of undercounting. So there are 12 schedules of the Constitution. You have 395 articles and then 12 schedules. So parts, chapters, articles. The individual provision is called an article. The sub-provisions are called clauses. Right? And as if this were not long enough, we've added 103 amendments to the Constitution and counting. So you have a long Constitution made longer by amendments, and that was the final output of the Constituent Assembly. We must not romanticize or trivialize the kinds of hard choices that constitution making in the 1940s demanded. It was clearly a time when there was high degrees of political consensus and goodwill among the political class. While there were deep disagreements about many issues, the people who came together to make the constitution could agree on this common understanding of the standard rules of the game that they could all agree with. How did they do this? They did this by arguing, deliberating in the assembly, and no doubt they did this by bargaining both in the assembly and outside the assembly in the subcommittees, elsewhere in the Congress assembly parties, and in other corridors and homes. But this is the nature of all political documents, and the Indian Constitution is no exception. By some combination of arguing and bargaining, we have the artifact that we now call the Constitution of India 1950. So, I trust at this point you have a fair idea of this constitution making process. We will share some basic documents with you, readings with you, that you can use to understand this at greater length. I now turn to the third of the 4 questions in week 2 of the course. I asked the question, now that we've gone through this painstaking process of making the constitution, is it unchangeable and for all times? I already referred to the 103 amendments, so you know that there is a structured political process by which the constitution can be changed. But let's focus on the ways in which a constitution can change. It's useful for us to understand the nature of the constitution as a living document. The first of these is through the process of interpretation. Now, interpretation-related changes are occurring all the time. We look at the constitutional text and we take a word like, say, what is the right to life in Article 21 of the Constitution, and what that right to life meant in 1950 may be quite different from what the right to life means in 2020. Just to give you 2 quick examples, there was no claim in the 1950s that privacy and dignity were ingredients of the right to life. This is a relatively new recognition by the Supreme Court. So courts, through their power of interpretation, allow a constitution to change. But notice that courts do not change the text of the constitution. They change very slowly the interpretation, the meaning of the constitution, but not change the text. How far can courts go while interpreting the constitution? It's not, there is no bright line test. We understand that judges are experts and specially trained to conduct constitutional interpretation. But we are aware that judges are not elected officials. They occupy their positions by virtue of their expertise. So they may interpret and move the constitution, but not alter it in a dramatic sense. We also are aware that judges who overstep these boundaries may raise concerns about what are the proper limits of judicial power, and whether, by intervening in other political questions, they are making a contribution, or they are actually juridifying politics, or they're making it politics too legal when politics should actually be more open-ended. Now, these are more abstract and theoretical questions, but I suppose for this session, it's important for us to recognize that as a question of interpretation, the Constitution is changing all the time. To be clear, it's not only judges who interpret the Constitution. Parliament interprets the Constitution while making laws and other policy. Key members of the executive branch interpret the Constitution. Lawyers are interpreting the Constitution all the time. Common citizens are interpreting the Constitution. And law teachers and legal academics are trying to write about how the Constitution should be interpreted. So interpretation is this widespread social exercise by which constitutional meaning may change. And that is one important way in which a constitution is updated and changes. The second way is through the process of amendment. I have not yet taken you into provisions of the Constitution, but I will mention one today, Article 368. Article 368 allows Parliament to amend the Constitution. But when we say amend, we mean change the text of the Constitution. Are these changes of the text of the Constitution limited or unlimited? Can Parliament change anything and everything and replace the Constitution? Or are there some limits to this change? In Indian constitutional history, we have developed a judicial doctrine that limits the extent to which a constitution can be changed by Parliament, which we call the basic structure doctrine. In my next slide and in the next 3-4 minutes, I'm going to spend a little bit of time talking about the basic structure doctrine to give you a broad idea of what the nature of that limit may be. There are other instances here around the 9th schedule of the Constitution that you might want to pay attention to if you're very interested in the question of constitutional limits. Many people think that if we give the power to the judiciary to determine the scope of constitutional amendment, then the judiciary will not be able to amend the Constitution. Will not allow the amendment of the Constitution, and the Constitution will freeze. There's no such fear because as we note that we have 104 amendments since 1950. I noticed in my earlier slide I said 103. It's not like an amendment has taken place in the last 4 minutes. I clearly counted it wrong in the earlier slide. So let's correct that to 104. 104 amendments since 1950, and other constitutions have been amended far less frequently. And you would notice that since 1973, it's not like the amending powers of Parliament have been unduly constrained. Now, can Parliament replace the Constitution? So we are now trying to distinguish between two kinds of change: ordinary piecemeal change and radical change of the Constitution, where the entire Constitution may be replaced or a substantial part of the Constitution may be replaced. This is both legally and politically a very different question from smaller changes of the Constitution. This issue has come to the fore in the mid-1970s when the Indira Gandhi government, which felt that it was under a kind of political siege, a siege not just from the opposition but from the court and from external forces and so on. Political history of the period gives us a rich idea of what some key actors at that time might have felt. But what it prompted the government to do was to make large amendments of the Constitution. Some of those amendments dealt with the election of the Prime Minister, other amendments dealt with property rights, and so on and so forth. It was in this phase, when large-scale amendments of the Constitution were being carried out, that this was challenged in the Keshavananda Bharati case. And the Keshavananda Bharati case, which was decided in 1973, said this kind of radical amendment, radical constitutional change, is not possible for Parliament to do. The court's judgment and the hearings related to court are very complicated, deserve close reading, not something that I'm going to do in this course. But what is important is that the court never said that nobody can change the Constitution, just that Parliament cannot change the Constitution. Maybe we can imagine that there are some other ways in which that can happen, but the court has not clearly laid out what are these other ways in which a Constitution may be changed in this radical fashion. So it placed a very strong fetter on Parliament. But this is a strong fetter on radical amendment, but not a strong fetter on everyday amendment, which is carried on in a relatively unhindered way. Now, in Keshavananda, 13 judges sat on the bench, one of the largest benches that had ever been constituted in the Supreme Court, and they outlined some basic features of the Constitution. They mentioned democracy, federalism, secularism, the idea that India is a sovereign republic, among others. And these issues, this is not a fixed list. The court may interpret and add basic features. For example, in the recent litigation around a National Judicial Appointments Commission, in what is known as the Fourth Judge's case, the Supreme Court held that judicial independence is a principle that is part of the basic structure, and any attempt to amend the Constitution that affected this judicial independence would be struck down as constitutionally invalid. This power to declare constitutional amendments invalid is an exceptional power. It's not a power that one finds in many other common law jurisdictions, or for that matter, many other jurisdictions. But significantly, there seems to be greater acceptance that this is an important and useful power in the comparative constitutional law academic discussion as well as court decisions. Now, many people loosely say, oh, that if indeed the Supreme Court says there are basic features of the Constitution, they should tell us what they are. And if they can't tell us what they are, they're just making it up. You know, tomorrow they'll declare something else as a basic feature, whatever catches the fancy of the bench of the day, that this is the nature of the basic structure doctrine. And this doesn't seem to be the case. For starters, the court has not enlarged the body of basic features of the Constitution too significantly. It has developed an incremental model, a common law model of making decisions one case at a time, which is an acknowledged way of adjudication for the Supreme Court on all other issues. And the basic structure doctrine and the basic features of the Constitution are no different. So let me stop here for lecture 2 of week 2 and broadly summarize. We began with 4 questions. How should constitutions be made? How did India make its constitution? Once you make a constitution, can a constitution change? And can Parliament replace the constitution? These are the 4 questions for week 2. We will come back with a few more resources and an assignment for you to do, and look forward to having you back for week 3 next week. Thank you.